It works same way.
All right. Well, welcome everyone to the March 20th, 2024 BZA work session. Rick has provided an agenda for us via email, which we have incorporated in the PowerPoint presentation to kind of guide discussion. So I feel like we can go ahead and just really hand it over to you guys to talk about the bylaws and just jump right into it if you'd like.
Okay, well, I think that probably the most time-consuming portion of the agenda, the rest of it should be pretty quickly, I think, is probably the bylaws discussion. So as if everyone recalls, probably a little over a year ago, we appointed Miss Malice and I to head up the bylaws committee. So we with BZA attorney Martin Krim drafted bylaws largely based off of Fairfax County's bylaws and in consultation with staff, and we revised them probably multiple times based on feedback, and this is kind of our work product to date. So staff has given comments on some particulars, and then we, through our council, has provided more comments for discussion tonight. So I think I should turn it over to Mr. Krim.
Mr. Kaplan?
Yes.
I'll just add one thing. I was going through my BZA file, and it appears that we started this project in 2017. That was the first.
Sadly, I recall that.
That was the first, in June of 2017, we met with staff for the first time to start.
I think in my research, I think that I have not found another jurisdiction in Virginia without bylaws. I have done an exhaustive search, but I've gone through, a good bunch of bylaws. And
So these are the bylaws files.
please.
All right. Thank you. So thank you. Yes, as Chair indicated, this is a set of bylaws based on the Fairfax County BZA bylaws. We have gone through several drafts to try to tailor them to you, and we had some questions I know that staff had and the board had. If we want to jump right into the comments, we could do that if that's acceptable to everybody. So at the bottom of page 1, and let me just say, when you go through a document after you haven't looked at it for a while, you find things that you missed. So one of the things I missed was page numbers. But the election of the BZA secretary, there was a comment, should we define the role of the secretary in these bylaws? And I really don't think so. I mean, it's going to necessarily change over time, and bylaws tend to be difficult to change. So let's just do that on an ad hoc basis, if you like. And
I think that because there's been so much, I think the secretary is an important role. So I think that maybe we do want to talk a little bit about it. I also, does the secretary have to be somebody who works for the county and the staff? Could it be one of us?
Yeah, it is. It can be one of you.
Maybe we should consider doing that.
I think that the reason why we have not had that is because it's a lot of work. Because it's making minutes. It's just a lot more work that as unpaid.
Right, but we had so much controversy with Blake being the secretary and all of the appeals that maybe it would be better if we just handled that all in-house.
That Blake did not do the appeals thing as secretary. He did that as BZA coordinator.
Well,
Yes,
I think we should. My point is, I think we should separate them.
Certainly. And what Fairfax County BZA has done is they have a clerk role as well as a secretary role. And the secretary is a member of the board and the clerk is not. The clerk is a staff member.
So like the clerk would be Blake, for instance.
Yes.
Okay. That
somebody appointed by the staff.
Okay.
By the staff.
Okay.
So
that makes a lot of sense to me. That's my 2 cents.
Okay.
And correct me if I'm wrong, but I don't believe there's like a statutory requirement that the secretary needs to be the one who takes the minutes. I believe even with if the BZA would like to elect someone to be the secretary, that person I could still do the minutes.
Well, they're going to need to define it from our perspective.
Right. So then I guess that would entail a discussion of what the secretary's role is.
Right. So there's only 2 statutorily prescribed roles for the secretary of the BZA. So, that's scheduling hearings and is it notifying of vacancies?
Yes.
So, so that's statutorily how it's set up. I think, and Blake and Arlova, y'all can correct me, but in the past, I think there's been a more of a the staff did a lot of things for the BZA. Now it seems the BZA wants to do a lot of things and make, shift some of those things over to y'all to make those decisions. So I think that's why the staff comment was there, just like, let's just have a understanding between the BZA and staff of who's going to do what.
Yeah.
And Martin used the word clerk. I'm not aware that we've ever used that word before. Yeah, we don't.
Use it with the planning.
Yeah.
What word would we use?
Well, you have a secretary. You can, staff is going to call it what staff, if staff will appoint a person to be, for better or lack of a word, a liaison with the BZA. Which it wouldn't necessarily be called clerk. I think Blake's title is
BZA coordinator.
so that's different from secretary.
Right. So, and we've had discussions previously about not wanting to tread on staff's toes. So that's where it becomes very important to have pretty clear demarcations between the BZA function and staff functions. One of the controversies that came up with the Fairfax County Board of Zoning Appeals bylaws was the designation of somebody as clerk, and then they meet so often they have a deputy clerk and assistant clerks, and so that became kind of then the question became, well, what if the BZA is not happy with one of those? They're happy with them all right now, but what if in a future day they become unhappy with one? There's a provision in their bylaws to deal with that. I was hoping to avoid that complication here, because you don't meet as often. But if that's something, if you're going to designate a clerk and say the clerk has an obligation to do bylaws, do minutes. Thank you. Let's just making sure you're paying attention. Then that's something that we would want to make sure that everybody was on the same page with. And would we do that in the bylaws, or would we do that by some other kind of arrangement?
I guess just a process question. Are we going to try to come to consensus on each of these as we go through? Or just kind of hear the back? And
I feel like this, since it's all kind of new, maybe that is something that we don't have to nail down, all the details. Maybe we get the general ideas, and then I think it might change too over time, which I guess we want the ability to do, right? Like if things, so we want some leeway in the bylaws, but we also, haven't defined everything exactly yet, because this would be a big change for us.
Right.
So we would want the ability to define the roles, and then maybe amend the bylaws if we need to, which we can do.
Which you can do, right? Absolutely. And so, if as it's written right now, all the secretary has to do under the bylaws is notify as to the vacancies.
What about the scheduling from the statute? From
this,
is that in there too?
I don't think it's in the bylaw.
Oh, okay.
I think that's in the statute.
Okay.
Correct me if I'm wrong, Ann.
The two things,
Yeah.
are in the statute. But
Okay.
I just want to make sure, are you talking about here, just at the very beginning?
Mhm.
That's,
There
I
is a,
didn't see the statutory duties mentioned in the bylaws.
yeah, it's in the next page, Article 2, number 6, the secretary shall notify the circuit court of any vacancies on the BZA.
Oh,
It's freshman.
I always err on the side of being as vague as legally possible.
Yeah.
I think, but I guess this Article 2 is election and duties of officers.
Mhm.
And our secretary / clerk / coordinator
Mhm.
is staff.
Right.
So I think there's a disconnect there.
Well, but the BZA secretary can be staff or it can be a member.
Okay.
If so, can
Mhm.
Oh, that's interesting.
someone speak? So what are the scheduling duties? So how far does that go? So when the statute says scheduling. What does that mean?
I'll note Steven has his hands up, by the way.
He has a lot to say about this. You can tell by his face. Right, what is it? Yeah. What
Right.
does
So
that
like
mean?
right. So like, brass tacks, if we say the BZA secretary has scheduling duties, what does that mean? And I'm not sure that offloading these two functions of scheduling and notice the circuit court of vacancies have anything really to do with the controversy that we were enthralled in for the year.
No, and I don't know that that's the whole reason that's not the entire reason that I brought it up, but I was pretty sure that they didn't have to be
No,
staff. And
definitely
if
doesn't have to
we
be
were
staff.
doing our own thing, then, we're making our bylaws, let's govern ourselves kind of
So,
thing.
so as it reads right now,
Well, so I'm sorry. So what would, right? Steven?
He couldn't hear you.
Steven, can you, sorry.
Hey, sorry. Before we got too far into things, I was recalling, and please correct me if I'm wrong, but I think the Code of Virginia actually has a third duty of the secretary. And I realize this might be skipping down to the end, but I think the secretary is also supposed to receive service for circuit court cases. And I didn't know if you wanted to discuss that.
It's-
Yeah, we have a
It's-
note to talk about that.
Yeah.
Yeah.
Okay.
I think we get to that further on.
Okay.
But I guess from the collective BZA standpoint, if we or Patty or someone we appoint is going to take on those duties, it seems that the biggest duty is scheduling. So like, what does that mean? Does that mean the secretary is going to be advertising? What does that mean?
Oh, yeah.
That's the question.
I mean, I guess what they would.
I don't know.
probably-
And that was the question. I don't know.
I know, I'm throwing it out
Right.
there. Maybe they would, like, when at the beginning of the meeting, the chairperson would say, does the secretary have any scheduling, something that we need to talk about? And
but
they wouldn't
scheduling-
schedule it without us voting on it, I assume.
But scheduling involves advertising the meeting.
Right. That's what I'm trying to figure out what.
I'm more saying for like the
What their
appeals, when we
responsibilities are.
schedule that. I mean, I don't think, then that person would work with the clerk.
And
I don't know if this should be me or staff,
I
but
don't know.
um,
I mean, I have no idea.
so I would think that staff will still need to take care of the
I would assume-
advertising and
Yeah.
Yeah.
and I would, and Blake, Stephen, Debbie, let me know. I think we could, so we could, the communication on scheduling, there's no reason it couldn't be, if, say it's one of you or Patty or somebody, that person coordinates with Blake or whoever the staff person liaison coordinator is.
Yeah.
So I don't think we need to get caught up in
Okay.
that. And correct me, staff, if I'm not.
Like, it wouldn't be any different than,
Than what we're doing, right.
Blake proposing our calendar, and then we look at it and say, no, I don't think so. And the secretary would be in charge of, working
right.
with Blake and then
Yeah. I mean,
bringing it to us.
It doesn't seem like it's a big deal whether, we elect staff as a secretary or one of us do it or Patty does it. It just, the duties seem pretty minor to be too concerned about who is like on paper secretary, I guess is my thought. So.
All right, so as it's written, is it sufficient?
I think it's sufficient.
Yeah.
You can certainly make
Just talking about who, but
who,
Yeah.
you can certainly change that. And then we would want to coordinate with staff and the county attorney's office to make sure we were all on the same page and nothing fell between two stools, as it were.
Is there an option though for an additional staff person that would be the secretary or take the minutes or,
Well, we have that now.
but I mean, it's Blake doing both roles. So is the idea that we would separate from him having to do both or?
Yeah, I don't know. Would the minutes fall with the secretary or would we keep that with staff? That's a big job, so I don't know.
Big job, right?
Need to stay with staff, wouldn't be a member of the board.
Good.
Yeah.
So,
Not surprised.
Not good for Blake.
so again, what's the secretary role if Blake is doing the minutes and the scheduling?
Well, he's not. He would work with us.
So the secretary role, whether it's a staff member or a member of the board, would be to notify the circuit court of vacancies or impending vacancies, to coordinate the scheduling and to accept service for a petition for writ of certiorari in the circuit court.
I think it also puts a barrier up between, not a barrier, but it puts a more defining role between us and the staff where there's some quasi, weirdness because he's the secretary, but he also works for the staff. And I think separating is probably a good idea, in my opinion.
So, receiving service.
Yeah.
How would the court know? Do we notify the court who the secretary is?
Would you notify the court who the secretary is? Yeah, well, the secretary would have communication only when they're statutorily called to do so, which is to notify of vacancies.
But it's not received service?
So there's two different kinds of services, and we're jumping ahead a little bit, but the kind of service we're talking about right now is for your normal writ of certiorari appeal from the Board of Zoning Appeals to the Circuit Court. That goes to the secretary. Right?
And so that's what you would prefer?
Oh,
That's not.
we don't have a position.
Okay.
Mm-hmm.
I would just, I don't know whether this is going to make it more complicated than we need to be, but
Okay.
just so y'all understand that the secretary is supposed to pull together the record in a writ of certiorari to circuit, court.
Mm.
So the order will be issued the BZA.
Right.
And then the secretary gets the record together and has to certify that it is the record of the BZA. So I'm
Right.
sorry, I don't mean to
No, that's a fair
get
point.
into the weeds.
And I think that's something that we would expect to share with staff on the heavy lifting, because we almost have to.
You'd have to.
Because we don't
we have a lot of the record.
Right. Right.
Yeah.
Well, even in a simple case, you're going to have a lot of documents that have been submitted there, and making sure that those are all in order is a big task.
And right, the five of us don't maintain documents, obviously.
Right. Well,
Well, I don't know, maybe you do. I mean, but
You
we
get
wouldn't be able to, staff would not have control of that.
right. That's another
obviously,
point.
Or your emails.
Of course, right,
Yeah.
of course.
So, but I don't know that those are part of the record.
Right.
That's
No, I'm
different.
just, I'm just for, a use permit or a variance or an appeal that would get appealed. We're not maintaining the official record, right? We might have our notes, we might have what we downloaded or what is provided by county, but that's not the record that goes to the circuit court. That's my point.
Right.
So they would need to work with the clerk or the
For sure.
liaison
Right.
to help do that.
Yeah, 'cause the county has the records. They're all,
Okay. So, well, and that brings us to the next point. If we're clear on the issue there, the next point is the accepting service on behalf of the BZA, and that's not for your normal run-of-the-mill writ of certiorari. That's if somebody files a declaratory judgment action against the Board of Zoning Appeals, or otherwise files a lawsuit against them. And so that's happened a few times, more in Fairfax than here, but that clarifies what needs to be done. I mean, there's a case in Fairfax right now where somebody served the clerk of the Board of Zoning Appeals on a writ of, well, it's to style an appeal, but it's not asking for a writ of certiorari. Anyway, it's a mess. And it's a pro se person, so they didn't know what they were doing and didn't know what they were supposed to be doing. But at least for those people who know enough to ask the question, having this on the agenda for the election of officers meeting allows you to appoint somebody to accept service for those weird situations.
Which recall, we did that with Patty. So as of now, the BZA passed a resolution for that type of service to go to Patty.
If we have counsel who is our counsel, should we have our counsel accept our service so that our attorney knows right away instead of Patty? We've retained you as our counsel.
Correct.
Right? Yeah.
Who recommended we appoint Patty for service? I'll
Oh,
let him speak to that.
Well,
I see this stuff all the time at work and it's usually there, some registered agent or something. So
yeah,
it made sense to me.
that does make a certain amount of sense. I'm not sure. I haven't thought about that at all. But it would probably make more sense to appoint my firm because I'm not always going to be available. What if I'm on vacation or something like that?
Then does it need to go to a specific person?
Well, you want to have enough clarity in the motion to appoint this person that the person who's trying to file the lawsuit can figure it out.
Right.
So, when the attorney or the pro se property owner wants to serve somebody, they want to look at it and say, well, what does this mean? You don't want them to say, what does this mean? You want them to say, oh, okay, I can serve this lawsuit on this person. So I think of it more like you could name my whole firm, and that makes it a little easier because then you don't have to track me down. But it does need to be.
I mean, not that I have any doubt or not
Would you put that in the
confidence.
bylaws,
Patty,
or
but-
would you just say the firm representing, and then they'd have to go to the staff to find out who that is?
It would be a motion. It would be part of your organizational meeting in March every year where you designate the person. It could vary from year to year, or in the middle of the year if that person's no longer available for whatever reason.
So we would just make a motion during one of the hearings.
Right. All this is saying this is part of your order of business for the organizational meeting.
Well, yes, that is important.
Okay.
Let me, before we move on, let me just redouble back on the secretary role. So I think the consensus is we want to track the definition of secretary with the responsibilities in the state code. And then I just wanted to make the point of, that it's independent of the bylaws, whether we continue to elect Blake as secretary or we do Patty or one of us, right? That's kind of, irrelevant to the bylaws. It's relevant to the, what we do,
Sure.
but we can, move forward on the bylaws and then change that however we want.
Agreed.
All right. So that would mean that
This is
on
in
page 2, Article 2, number 6, where it's describing duties, we would expand upon that to include the other duties.
The other two.
I think that's the consensus that I'm
Yeah.
gathering.
Yeah.
Yeah. So, that brings me to a point, which is this is a document for several different audiences. It's for you all, and particularly for new members as they come on to understand what the duties are, or maybe somebody who's been offered an opportunity to serve and wants to know what's involved. It's also a document to help the staff work with the board to see what your expectations are. And then it serves the public because members of the public, attorneys and non-attorneys, are going to be looking at this and saying, what does the Board of Zoning Appeals do? How do I approach it? How do I interact with it? And so if you have that kind of approach to this exercise of drafting, it helps to show why some things are in there, because if we want to make it really simple for people who may have no legal experience, certainly no zoning experience, then you want to lay out a lot of things that you wouldn't have to lay out if it was just for the board itself. Right? So
Is there anywhere that this defines what the staff's duties and roles are, or not?
well, by exclusion, yes, because if it's things that needs to be done, and we're not saying we the Board of Zoning Appeals are doing it, then it kind of falls to staff. But we don't want to have something where we say this staff position or this staff person does something, because that changes with the next reorg. And we don't want to say, how it will be done. That's entirely in staff's hands as to how they handle things like the advertising. Okay. Mm-hmm.
Section 2, so the call a special meeting with 5 days notice.
Yes, this.
Do we have to, does that work with public notice? Like, don't we still have to
That
give them a week or 2 weeks or something?
I think it's 3 days.
Oh,
tracks state
Cool.
statute.
great.
Right.
There's different definitions on what type of meeting and special.
Special,
Yeah,
right,
exactly.
Then I'm good. Cool.
So, for example, you might need to call a special meeting for an item that's already been advertised and doesn't need to be re-advertised. I'm blanking on exactly what the situation would be, but this is just providing for that opportunity if the need arises.
Cool.
I think one of the closed sessions we did previously probably have qualified for that as well.
Mhm. Okay. Any sufficiently long document has typos in it. On the middle of page 3, there's a stray section mark that I will need to get rid of. And in 5C, we struck all of the examples under that, so we need to get rid of the word including. So I'll fix those and a couple other typos as we go along. Page 4, there's a comment on the disqualification or recusal. And there's a question about the 24-hour notice requirement, which really, the 24-hour notice requirement is comes into play when you have an alternate. You don't currently have any alternates. So if you had an alternate, you would want to make sure that they understood that everybody understood that if you knew you're going to be absent, you give the chair at least 24 hours notice that you're going to be absent. And then the purpose of that 24-hour notice is for the chair to notify an alternate that they may be needed at the next meeting. But I don't see that as conflicting with the disqualification or recusal, because if you're disqualifying yourself, if you're disqualified by law, or if you're recusing yourself as a matter of your personal ethics, then you can do that at the meeting, and you could also have notified the chair 24 hours in advance of that, which is certainly appreciated. Okay.
I don't see it in this write-up, but did we have something that said if you had a recusal or something? I thought I researched it saying you had to notify the secretary.
Is that right?
But I don't know what document it was, but when I guess the last the time I did that, I looked at something that said that.
I'm not sure.
Sure what document.
I'll make a note of that, and we will.
Because I asked the question of who was our secretary.
Right. And I think I told you to notify Blake and Patty.
Yeah.
Just to cover our bases.
Right.
All right.
Okay. All right. Thanks for that. And then 6C is the consent agenda. That's a pretty commonly used term that for elected bodies and planning commissions and all the folks. And it just refers to the fact that nobody wants to debate any of these items, so you're just going to vote on them once, rather than saying vote on the minutes of this meeting, vote on the minutes of this next meeting, vote on the minutes of this third meeting. You just vote on all the minutes that are before you as one vote. Yeah. Right. Correct. It's just a way to streamline the agenda a little bit.
And like the goal, most of the goal here is, as you see, is like just documenting the processes that we've already been doing. So, our intent here is not to make a whole lot of change. It's more to just formalize and provide transparency.
Okay. All right. So a bunch of comments on page 5. So we made an edit in Romanet 3 there, consideration of whether to accept applications, because the word cases understandably caused some reaction that what do we mean by that? What is the intent? And the intent was just to say that if the staff thinks that BZA should not take the use permit, appeal, or variance, then we need to have a discussion about why. And so that would be, could be something really simple, like they haven't paid their fee, in which case we say, yeah, you haven't paid your fee. We'll give you a deadline to pay your fee, or else we're going to dismiss your case. Or it could be something like, and it could be something like they filed with the wrong party. They really want to rezoning. And the staff is saying, no, what you're asking the board of zoning appeals to do, they can't do because it's a rezoning. So we want a way to clear that off of the calendar, clear that off the decks.
With appeals, we do want those to be paid before we'll schedule, but the use permit and the variances, I think, by the time they're processed, they're not really at a point like where, they don't really get to us until they're already done. So I don't know that we want to get involved in sometimes they take months.
Sure.
But appeals, I think, are different, and maybe we should
Right. Well, it's
like separate them out a little bit.
I kind of Romanet 3 there is just the family of things that the staff thinks this really shouldn't come before the Board of Zoning Appeals, but the applicant or the appellant thinks that they should. And so somebody's got to resolve that dispute. It's like, if you're in general district court and you file something and the parties say, well, that shouldn't even be before this court, it's not within the jurisdiction of the court, then somebody's going to make a decision, and that's going to be the judge. in your case, it would be the Board of Zoning Appeals that makes a decision about that. And, it could be anything from just a mistake because some pro se person doesn't know how to file something, or it might be something really wacky. I mean, you might have a sovereign citizen come in here and want to declare the county of Arlington to be void, and well, this isn't the body to do that.
So to Lindsay's point, consideration of whether to accept the application. It's not whether we hear the application, it's whether we accept the application. There's a distinction there, right?
Right, because you later on you have a provision in here for scheduling things if and giving a deadline for
Right.
people to have things heard.
So I'm trying to think of a case where there's a variance that staff says it's incomplete. There's a standard for you to accept a variance or a use permit, right?
Yeah.
I mean, there's a standard for us to accept any application, right?
And so if this would cover a case where the appellant or the applicant said, I submitted it, and you saying it's not complete, and they argue with you.
Sounds like it. Yes. Yeah.
Exactly.
It's not scheduling yet. It's just your application's not complete. We can't do anything with it.
Right, and if somebody says yes, it is complete. Yes, it is complete. Then somebody's got to make a decision about that. Well,
We don't get cases on our agenda that are ready to go.
Well, that's the question is it ready to go? And if there's a dispute between staff and the applicant, it's a little peculiar to have the staff be the gatekeeper for that.
We would then have to support staff and say, no, it's not complete. We're not.
Well,
Or-
it depends on the circumstances,
Yeah.
right? I mean, but somebody's got to make a decision. Okay. The next, yeah. Okay,
Yeah, I can do it
I
later.
would-
I'll email it.
I
okay,
guess-
super.
I appreciate your explanation, because without that, it sounds like you're saying everything comes to you to decide whether or not it's acceptable, which would not be sustainable.
That's-
So
No, definitely not.
I appreciated the explanation, and I do think it needs to be clarified,
Okay,
because I don't think that says what you just explained.
all right. Well, I'm open to alternate language. Absolutely.
And
That's where the county staff indicates the BZA should not take the case.
Like conflicts between staff and applicants or something about the conflicts between staff and applicants about the.
Whether it's ripe for a Board of Zoning Appeals hearing.
Do you have a preference on how to say that more clearly?
We can look at it. I guess to me, it's not a case if it's not a complete application, right? Like it's not even, it's not even up for consideration to be heard. If I don't have a plat that shows the location, like if the drawings are in, it's not a case, right? It hasn't even risen to the level to get a number to go anywhere.
Right.
Yes.
If we,
But eventually
That was my.
Yeah. it's already happening. Yeah.
Well, at some point it may need to be.
It could.
Yeah.
And
this may be just a way to put an end to these silly arguments.
Yep.
If there's no plat,
Yep.
they come before you, and you guys in the BZA are going to say, well, where's the plat?
that's
Which,
fine.
which we just did. We just did that,
Yeah.
right?
Okay.
Or we were unhappy with the plat and we made them come back,
Right.
right?
so if we remove the word the case makes it sound like there is an applicant.
Yeah,
Well,
I think we can,
I think case is gone
yeah,
already.
we can work on it.
There's a
That's
second.
Oh, no,
definition
yeah, there
of
is,
the
okay.
case.
Yeah.
Okay.
That-
All right, let's
Okay,
work
well,
on
we can
that.
work on that.
Let's work on that because I have that be clear. And then F is public comment on non-agenda BZA matters. And they also picked up a comment. The intent of this is, well, first of all, yeah, open comment periods are not required for the Board of Zoning Appeals. They're only required for governing bodies. But all bodies are encouraged to have public comment in the FOIA Act, in the Freedom of Information Act. And the idea here is, again, is somewhat of a safety valve. If somebody has a comment that they want to bring to your attention that doesn't fit into any other category, and I don't expect it will be used very often, but if there's something that somebody needs to bring to your attention, let's say they're unhappy with,
Like this letter that you guys got.
yeah, I haven't had a chance to look at
Seems
it
like
yet,
an
but
example of something.
yeah, greater transparency.
Are you suggesting that there'd be public comment on every agenda?
Well, it wouldn't have to be every agenda. You could make it quarterly
Because
or
with
something
the
like that.
issue so controversial right
Mhm.
now. We could literally have people show up at every meeting and suck out all the oxygen.
Well, it is the last thing before adjournment. So they would have to wait until you were there, and you can limit the amount of time available for public comment. It's no, you can rearrange it by a majority vote. You do not.
Because the board does public comment and consent right up front.
Yeah, a lot of places do public comment right up front, or they will do it at a time certain. So if they like start at 5:30, they'll have time certain public comment at 7, so that people know when to come, and people commuting can have a better opportunity to appear.
Slippery slope.
It can be. But we used effectively that when Craig came to
The Myers case.
yeah, came to talk to you about Craig Blakely talked to you about the not Blakely, what is his last name?
Maybe,
Plus your
The Myers.
Yeah,
maybe it would-
Blakely. Yeah.
Blakely, Craig, yeah,
Yeah.
I think that's right.
Okay. So that was that was a situation where it was, effectively a safety valve, bringing something to your attention that was not otherwise brought to your attention. Okay.
you don't have to, I mean, you could still call for public comment whenever you wanted to,
Mhm.
but
Without
not-
having it on.
Without
Not-
drawing attention to it.
well,
Without
not
being-
putting it in the bylaws.
Yeah, that's fine.
But
Yeah.
Don't put it.
Okay.
Well, is there a way to keep it in just so that we know that's an option for us?
In the bylaws, but not as an agenda item.
Right.
So
So some,
move to a not part of the agenda to say the
That's an option.
so an attorney who's reading the bylaws,
Reason why we can't put anything on it. I mean, we did it there. I mean, if we decided on a given
yeah.
night. That
no, yeah,
You know,
I
if
guess,
we had to sit through 2 EHO appeals, we could put a public comment on that night, but otherwise.
I mean, I guess, my thought off the cuff is that, an attorney who's representing someone who feels aggrieved by the process, then has knowledge to know that they can be heard on that, kind of like what happened with the Myers.
Apart from their 20 minutes.
Well, they didn't have their 20 minutes at the beginning, they didn't get their 20 minutes until they appeared before us.
So just to think about that a minute. Could the appellant have written us a letter?
Sure.
Would that, I mean, I sense,
So as public.
I don't know that everyone can, you might want to move that closer to you. Just mindful of the people listening. I don't think
People?
they heard everything you said.
so I'm just saying, if public comment seems objectionable, could someone communicate with us in writing?
Well-
Would that be as effective, or is there a downside to that?
You have to be careful because of the ban on ex parte communication. So nobody can communicate with you on,
Communicate with Patty?
you would have to make sure that they communicated with the staff at the same time they communicated with you. And how are you going to do that if you just accept a letter?
Yeah, and that's why we have Patty, is to,
Mhm.
for those ex parte. So
I don't feel like it needs to be in the bylaws. We can do it whenever we want. We don't, like, we did it before. It doesn't have to be disclosed. If we decide we want to do it, then I still have the option to do it.
Mhm.
Something needs to be written down.
So the problem is though, how does someone from
Does someone
the
know?
outside know that they can, ask us?
Well, you had a resolution in place.
They expressed their concern and they wanted to come before us, and you guys agreed, so they can just do the same thing again. And they want to come and talk.
Or they can be encouraged to write a letter.
All right, well, that seems to be no consensus on that one. Let's set that aside if we might and come back to that. The next item in the language just before paragraph 7 is a question about agenda items not yet heard by the time of adjournment become agenda items on a following agenda. And that's we did not want to say the next agenda because it might not be the next meeting. It might have to be advertised. We don't know what the schedule will be. It may well be a different meeting, and the applicant may well want a different meeting. No, I can't do next month because I'm having my son's bar mitzvah, whatever it is. You don't want to have a situation where the bylaws demand that it be the next meeting. So that's all that's saying, and that's really up to staff to schedule that with the applicant. Then number 8. So this is an agenda for each meeting will be prepared in consultation with the BZA chair. And I didn't want to get specific to say it has to be a meeting or an email. I'm definitely a believer in emails if there's, that opportunity. I understand the current practice is to have everything in first come, first serve order. So if you file first, then you will be heard first. And that probably makes sense for most situations. It might not make sense for some. And so, it just seems to me that the consultation with the BZA chair is simply, here's my draft agenda. Are you okay with it in an email? That's a consultation. And so if you don't get a reply from the email, then what the staff puts in the email flies. Current policy to get email to the board chair?
No, I mean, I know staff prepares the agenda based on the filings, which are almost always in numerical order. But before it's published, do you consult with the chair?
No, not typically.
We also don't have the applications at that time, so how could the chair really have any opinion? Other than to say, yes, it's fine, I'm looking at a bunch of numbers and the advertisements, but without anything behind it, it doesn't really mean anything.
Well, so sometimes there actually is consultation because, it's been sort of informal because staff might say, we've got 20 cases on our agenda for May. What do you want to do? Right. So.
Right. I was
So,
just about to let you know, if we get back into like pandemic level era cases where there's 25, 30, 40 items on the agenda, then we could do some reworking kind of informally behind the scenes.
that's what
And
we
that was
did.
kind of the idea, is just to increase communication.
So I don't see a downside to.
I think this,
Should be, can be prepared.
May.
Instead of, well,
Maybe.
maybe prepared.
Or just, I don't like the passive voice because that doesn't tell you who's doing it. Staff will prepare a draft agenda and submit it to the BZA chair for.
that's where this is where our questions came from, because the BZA dictating what staff will and will not be doing, they don't have the jurisdiction or authority to do that. So this is one that I'm not sure. It seems to be working okay because so I don't know why it needs to be in the bylaws, because it is, it is not clear right here, the way it's written, who's doing it. That was my first question when I looked at this is
Right.
who's drafting the agenda?
Right.
It's not clear because it doesn't have staff.
No, it doesn't say that.
So,
Well, so ultimately, the Board of Zoning Appeals is in control of its own agenda, and it can do that in a number of ways. It can do that at the moment when they're at the meeting, or they could delegate the authority to do that to somebody else. So this is a delegation of authority to the BZA chair, and whoever's putting together a draft agenda.
Yeah, but it's still directing staff. I mean, I'm unclear what language you're talking about right now. As it's written
Still
or
talking
with
about
your rewrite?
as written, it's.
Well, the reason we made the comment, and maybe you guys can think of specifics, staff can, but it's confusing to staff what y'all are looking for
Mhm.
because of current, what the practice has been. So again, I think we're all just trying to seek clarity so we can understand what y'all are wanting. But we would, I think we've been drafting, the staff person has been taking care of the agendas and consulting the chair as needed, right? Is that what you said? I don't want to be putting words in your mouth.
So
Sorry, my microphone keeps dying. Yeah. Thank you, Martin. Yeah, so typically for instance, right now we're preparing the April agenda and we expect to publish it around April 3rd. It's largely done. We've had 2 agenda review meetings with zoning plan review to finalize it. But we're not planning to share the draft with you. We'll publish it online in about 2 weeks when the newspaper ad runs.
So what would you have done if there were 25 cases?
Generally, I mean, right now, informally, Rick and I will chat like at the end of a hearing, for instance, like how's next month look? And I'll give them an update. We're doing agenda review maybe in a day or two, and we'll have a better sense. I think about 12, for instance, for April. It's climbed up a little bit. We've gotten a few submissions. So I think we're now looking at about 16 cases for April, for instance. But yeah, other than putting it online, about 2 weeks ahead of the meeting, we have not been sharing a draft with anyone beforehand or, seeking, consultation and coordination on the items on that agenda.
So
Any need?
I don't either. I feel like if it's working, it's not.
So well, I'm just, kind of the idea is so that, people that are new to BZA know kind of what's going to work. And that's why I'm just trying to explore this. If the BZA said, if, sometimes we've said, we don't want to hear more than 15 cases a night. Would you consider that direction?
It's information. It's information that we could use. I get it. And first of all, Stephen has his hand up and he kind of dealt with this probably the most. I think we're thinking of pandemic level situations where we have extraordinary things happening. And certainly if extraordinary things are happening, we're going to have to talk about them.
Right.
I think the reaction is like, does it need to be written down as you shall do this when we're already working together and talking about things? And certainly if a meeting where it's a higher than normal level of caseload, we're going to communicate about it because that's what we do. But
So-
I just want to recognize Stephen, who's patiently got his hand up there.
Thanks, Arlova. I really wasn't going to say much more than you did, though. Honestly, I mean, we've been in situations where we've had a lot of cases, and those are times when we will reach out to see what you guys want to do. And typically the options are, do you want to hear them all in one night or do you want to hear them in 2? And we've done that not just with the extraordinary number of cases, but we've been doing that with the appeals as well. There's nothing that prevents us from doing that without this written here. We've been doing it for a long time and it has seemed to work well in our opinions. And it's up to you if you think it needs codification, I guess.
Yeah, I mean, I think that the intent here was not to really have a huge change in what we were doing, right? It was just more of codifying what we're doing, and clearly this is one of the more controversial, what I thought was benign on our part on this provision, right? So.
Okay. What's the will of the board? Do you want to just take out that sentence and keep things?
So does that mean all of 8 or just the highlighted?
Just the first sentence. I don't think
Okay.
there's an objection to the second sentence.
Okay.
I actually
No,
did have
I-
I actually did have a question.
Yeah.
A question about the second sentence.
Well, because
So
Once it's on the agenda, it's on the agenda.
once it's on
No.
the agenda and it's a published agenda, then the only way to remove it is if the BZA votes to remove it. Because the other alternative would be staff removes it, or the applicant says, I want this removed, and the staff does it for them.
Then we
But I-
just do it. Think the thing. The agenda's already set. Then we have people that withdraw their applications the day of.
Sure,
So we just say it in the record and we move on.
right. And that's what this is.
Here.
This is what, this is capturing the fact that there's no other way to have that done. It's not like something's going to disappear off your agenda without BZA having to act on it.
So this is meant to address withdrawals or things like that.
Then we
Is
should
that-
say that. We should say if an application is being withdrawn or whatever the instances are, then the BZA will vote to remove it from the agenda.
Right.
I don't know, whatever. I don't really understand. don't know how this is
Can we
gonna
let,
begin with.
let's let them answer.
So, yeah, I mean, the idea there is once the BZA agenda has been created, things should not be removed from it without your action. And so that applies not just in somebody withdraws, but if somebody wants to have it postponed, you know, once it's on the agenda, then it's your agenda. The Board of Zoning Appeals owns that agenda and it can't be changed in any other way. And this is putting down, informing the public and staff that that's the only way that things can be removed.
I think it needs to be a little more specific than no matter.
Okay,
no case.
well, I mean, so, okay,
So the practical result is it was posted, it was advertised. And then the evening of the hearing, everything that was posted gets discussed. Even if the discussion is, we got a letter yesterday and this person is no longer interested.
No.
And so,
no, it's just, this person's no longer interested, here's their letter. I ask that you remove this from the agenda.
We have
Okay.
withdrawals and deferrals all the time in our packet.
Yeah.
Right.
And we act on each one of them
Right.
pretty quickly because
Right.
obviously
They're really, right, they're really quick, right?
Yeah.
they're not removed.
so
from
the
agenda.
action is removing it from, this is my issue. I've had a issue with the idea that you can deny a withdrawal. So the vote on it doesn't make any sense to me. So that I'm literally trying to understand what is happening. Like if I don't want to do something, you can't make me do it. Right? Like just because it's
So-
on your agenda.
We don't.
So what is the BZA doing? Like they are removing, I'm literally asking, like they're just talking about and removing something from the agenda. They're not voting
So,
on it.
right, they are removing it from the agenda by either unanimous consent or
Okay.
by a vote. And it could be a withdrawal, it could be a deferral, it could be a number of different things, or it could be a situation where, there's somebody thinks that it shouldn't be on this agenda, but that's not a decision for anybody to make other than the Board of Zoning Appeals. Whatever that reasoning is, that should be brought to the Board of Zoning Appeals and let them make the decision about whether it remains on their agenda or not, because it's their agenda. It's not the staff's agenda. at that
I'm
point.
not talking about staff, I'm talking about the person who made a different
It's
decision.
not it's not
I'm talking
their,
about the applicant,
it's
not us. We could
Right.
care less.
right. It's not their decision either to remove something from the BZA agenda. It's the
Okay.
BZA's decision. It's the BZA's agenda. They control their agenda.
All right.
Let's, so we're in consensus to remove the first sentence, but there's some disagreement about the second.
Is there on the second?
I just wanted to understand it.
You okay with
Okay.
the second?
Okay. Then next sentence, next section 9, minutes of meetings will be prepared promptly and are approved by a vote of the BZA generally at the following meeting. This is just to establish an expectation, because the word generally, it is not a requirement for anybody to do anything. It's just setting what the expectation is for the Board of Zoning Appeals minutes to be approved in a timely fashion, because they're supposed to be approved in a timely fashion. And there are boards of zoning appeals that have backlogs of years of minutes that haven't been approved. And that's a problem for everybody. staff, public, and the applicants. They don't know what happened at a meeting because there haven't been any approved minutes of that meeting. And now sometimes they have a document that's, executed that can show that, but it's better to have the minutes, in my opinion, to have the evidence that the matter was discussed and heard and decided upon.
Like we had 2 appeals hearings in January. We did 3 sets of meetings at one time. We didn't do
It's just generally, right? So
It's not
the idea was this is just kind of documenting our process. And so if it doesn't happen,
Well, promptly is in the first line. Okay,
You have a suggestion?
Not yet.
okay. All right, well, we'll bracket that.
usually,
That's not even better. Any better. All right, then the next page, page 6, and on into page 7, both Article 5 and Article 6 got flagged with question that these appear to be functions of staff, and we aren't clear why these need to be included in the BZA's bylaws. Happy to discuss intent behind these. So the intent behind these was to set out the expectations for the public and staff and the board itself as to how things get put before you. And so Article 5, Section 1 says you have to use the county forms. Whatever those forms are, they might change, probably will change, but whatever those forms are, if there's no required form, you have to do something, put it in writing. And so I don't know if you have a form for everything that could possibly come before the Board of Zoning Appeals, but it's so rare to see somebody apply for a determination about the location of a zoning district line that I doubt you have a form. Maybe you tell me that you do. But in any event,
I've never seen one.
I've never seen one in my life either. No, that's not true. I had one. In the future, there might be other things that are added to the BZA's plate by the General Assembly. So whatever those forms are, if they exist, you have to use them. If there's no form, then you have to put it in writing. And then the rest of this is, telling you to follow the zoning ordinance. So this is particularly helpful, I think, for pro se people who don't know what they're doing. And then Article 5, Section 2, second sentence, is designed to keep things from becoming stale. So let's say you have a zoning violation. Somebody says, well, I can fix that zoning violation by a variance request. And I filed my variance request, but I don't want it heard yet. I want to keep putting it off. I want to keep putting it off for 2 or 3 years, and then I'll sell the property.
We've had that.
We've had that.
Right. And so this is to say, we're not going to just accept that on face value. We're going to put that on our after agenda item and consider whether to set an action or a review date, because there may be perfectly good reasons why they can't get the variance that they need. Maybe they need to buy 2 feet from their neighbor, 2 linear feet, along the length of the whole property line. Maybe, because I've seen that happen. And those things never come to fruition because the people never want to sell. But that's an aside. So whatever the reason is, we want to have an opportunity for the Board of Zoning Appeals to say, we're not going to let this remain open forever. We're going to set a date. If you're not ready on that date, we're going to dismiss it.
I really am unhappy about it. I don't like the after or whatever it's called. Well, it means something that's going to happen after the meeting's over and there's going to be more items. I mean, that's what it means to me. And I trust Arlova and the staff to speak sharply to people who, don't have their stuff together in a timely way. And why would it come to us when it's managed, when the timeliness and the completeness of an application is handled by the staff?
So the term after agenda item is a little bit of a misnomer because it's part of the agenda. But it is, I borrowed that from the Fairfax Board of Zoning Appeals bylaws. And so they have had that as a practice for many a year. And the idea is to take care of things that are not full hearings, but need to be addressed in some fashion. And so if if you don't like that provision, you certainly don't have to do that. It's just something to keep the decks clear.
Staff manages.
What I think this is different than that situation. What I thought this referred to was, and I don't know if it's the address you mentioned, like the request that was a complete application, right? It came to us and then the owner every month asked for a deferral for like 2 years.
Right.
So it's beyond us determining whether they have a complete application. It came in, it was heard maybe once, and then I think we said, we need more information from you. And so every month we got an email like, oh, I'm not ready, and it was deferred. And we definitely can't like draw a line and say
Right.
you've had too many deferrals. Like that does have to come
That would
back.
come to us, right?
And I kind of remember you saying, can't we just deny it? Like, when can we move this along? Yeah.
But that might not be enough. There might be somebody who's on active duty military and just can't get it done before they come back from Iraq.
And when they get
Well, something like a violation that we can't just dismiss. There's a violation that has to be heard, right? So it's not, we can't just say you can defer that violation twice and they're overseas serving. Like we hear appeals on violations.
Somebody, a code enforcement violation.
Right.
So
I don't think,
Trying to seek BZA approval to satisfy a code violation.
And the issue with the
To
active
resolve it.
military is it's federal law that supersedes whatever we want to do here. So
Arlova, is if there's, let's say, a code enforcement action and they file a variance, for instance, to correct,
Mhm.
to stop the clock, to stop enforcement. Does that mean that they've also paid the fee?
Yes.
So they have to pay the fee in order to stop enforcement.
To be a real
To
application
be a-
that's before you.
right. And
Yeah.
so then I guess there's got, right there, I think you would agree that there's got to be a way to then not make that take 5 years,
Yes.
right? And I think that's kind of one of the scenarios that this is kind of getting at.
So
Yeah.
if we didn't call it an after agenda item, we just said put it on the agenda,
yes,
would that do it?
yeah, it's just a question of
case number and be advertised.
Yeah, definitely.
If it goes through the regular process.
Yeah, and we'll just, because after agenda just meant it goes later in the agenda. It's not, it's not at the front of the agenda. It's a matter that we'll hear
Or-
after all the other
Right.
cases have been heard.
Or how about the example of an appeal that someone never pays their fee, right? Staff probably wants that off of, I don't want to say agenda, but off of your books or, out of the system. That would be another way to, after 60, 90 days, put it before us so we can dismiss it.
And the idea of the after agenda was just a way to group these random
That
things.
like aren't
together.
like a full-fledged hearing, but they still need a hearing to get it dismissed.
Not when they're deferred.
I think if you're
deferrals.
deferring,
It doesn't have.
And then this
the numbering might.
this codifies giving staff that authority to put it on the agenda.
Because it's case number 234.
okay. Why don't we tweak that and come back
Anne
with
has a-
another?
Oh,
I'm sorry, Olivia.
She thought
Never
I had
mind.
a comment
I thought she
about,
was trying to.
I don't have a comment about that, but I did want to back up to number 1 under Article 5.
Okay,
Sorry about that.
no problem.
Did you want to say something about number 2 though, Martin?
No, I was just going to say that we can rename after agenda items and stuff. I don't have any dog in that fight.
I was just going to suggest that could we possibly maybe come up with a little bit different language on made by forms supplied by county staff? I feel like it probably needs to be like the process that is set up. Also, it's not just filling out a
Forms
piece.
and process.
Yeah, that makes
Yeah,
sense.
I mean, as set forth by county staff or something, like county staff decides it's gonna, buy permit Arlington and set it up the way it's set up. So I just think if we can come up with words, if y'all are okay
Right.
with that, to make
Yeah.
it a little broader.
Yeah, I mean, and that's
but
the exact intent of
Okay,
of
that's-
what that was. We're, like I said, a lot of this is just kind of wordsmithing and getting
Gotcha.
the process that we don't want to usurp your process. We don't want to come up with our own process, right? So
Right.
Perfect.
definitely.
Okay.
Okay, thanks.
Sure. All right. So I'm going to make a note that B2 draft. So going through Article 5 point by point, then if an application is deficient and an applicant insists on a hearing, then we put it on the agenda for some decision to be made. And that's what we discussed before.
Do they have a right to insist on a hearing?
Well, they don't have the right to insist on a hearing, but they're going to need to come to the Board of Zoning Appeals and tell them why the staff is wrong, why they think the staff is not right about the application is deficient. And so,
Is that gonna have to be advertised and all of that?
no, I don't think so. Why would it need to be advertised? It's not a public hearing.
Yeah.
It would be at a public meeting.
Okay.
But we're not deciding on the merit, the final.
And that
part of
would
the case.
be include even like incomplete in that they hadn't paid their fee?
Well,
Yeah,
so
we
what if
can't-
there's a dispute about, I know, well, we can't have a hearing with that if they haven't paid their fee. I agree. But what if there's a dispute as to what the fee should be? I don't know how you set your fees.
Well, that's not the BZA. The BZA doesn't set the fees, county
Right.
board does.
Right. But who decides whether they've paid the fees? If there's a dispute between the applicant and staff as to whether the proper fees have been paid.
Well, that's. Yeah, it's like any fee that's paid.
Okay. Well, I mean, I guess they could file a mandamus against you. I was just kind of
Yeah,
hoping to resolve that in another way.
So, seemed like a safety valve,
Mhm.
of a way for you to clear your backlogs without. Added
I love that you
controversy.
guys think that there are people out here demanding. There are lots of people demanding hearings
is it
that
me?
we aren't allowing them to have, but I kind of, I guess.
Well, say
for
it's not the fee.
scenario that none of us is thinking of.
Say it's not the fees. Let's
Yeah.
leave the fees aside for a moment. Let's just say you think that the application is deficient because it doesn't identify a hardship for a variance. It doesn't identify the
I would, I don't know if I'd use that. I would say maybe if there's like a ownership thing that's not clear, like
Yeah.
we don't, you haven't demonstrated,
yeah,
you haven't given us a disclosure statement, or you haven't
right.
it's unclear you have the authority to
Right.
make this
This-
request,
this
because
house
I don't
is in the
think,
name
I
of
don't know
the-
that you own it.
Right, this house is
Like
in the
that
name of
might be an
XYZ.
argument. Yeah,
Had a case where the neighbors claimed that the people didn't own the property.
right.
Right. So, I mean, there's weird things that could happen, and this is just a safety valve, whether it ever gets used or not. Number 4, notwithstanding other provisions, these bylaws, all applications, regardless of merit standing, are entitled to be brought to the BZA for hearing. That's similar to the resolution that the board adopted last year. Okay. Moving on to Article 6, processing of application. Again, this is the process question. Use the county process.
Sorry, Martin, I think we may need to back up. I think this is where it's very unclear to us what y'all's desire is, because we've been told a couple different things since we have started this process. So since the first resolution was passed.
Mhm.
So that's why
Right.
I think clarity would be helpful, because again, we seem to kind of be saying the same thing over. Like, I still don't know if number 3 involves like fees paid or not. And what does, notwithstanding, so regardless of what's in the bylaws, all applications regardless of merit or standing, are entitled to be brought to the BZA. So that include fees paid,
Okay, I see what you're
anything,
saying.
like everything. It's
say-
incredibly broad. And so,
Notwithstanding other provisions in these bylaws, I see what you're saying about that.
but also every application is entitled to a hearing. That's a pretty broad
Well,
statement, and I'm not sure
So
how
maybe
we
that could be,
interpret that as
sure.
staff.
What if we rephrase that to say, determinations of merit or standing are only made by the Board of Zoning Appeals?
Sure. Yeah, that's much clearer.
That good
Yeah.
for you?
Yeah, I like that.
Yeah.
I think that makes sense.
Okay, done.
Oh, it's an easy one.
So Article 6, processing applications, again, we're saying go do what the county tells you to do. And maybe that combines with your revision of Article 5, Section 1. Maybe we don't need that,
Yeah.
but or we could put the additional language in 6.1. 6.2, applicants must be notified. Again, I don't like the passive voice. I use it in this situation because I don't know who's going to be doing it. This task is obviously, it could be the staff that is doing this. It probably is. And then the notice by U.S. mail, unless the applicant has provided an email address or similar means for electronic notification. Is there any objection to that? Okay. There's another typo in 3.
Sorry, Martin, could I
Yeah.
actually pause on that one? Just part of our process, we currently have all applications taken in through the Permit Arlington system, and to submit an application in the Arlington system, you have to set up an account. To set up an account, you actually have to provide an email address.
Oh, you
And
do.
so all applicants have provided an email address before they have submitted a application. So I wasn't sure. I was pretty sure not everyone was aware of that because it's
I wasn't.
Our process. And I wasn't sure if that knowledge might change this portion.
Yeah, that would change things. Of course, email has only been around for 30 some years and it won't be the method of choice in another 30 years. So I don't know to what extent we want to change that. This would just provide a default. Everybody's going to have provided an email address for. Oh my gosh! Well, it's a lot older. In many ways,
Statutorily required.
yeah, built the United States itself. So. Oh my gosh! Don't get me started on that. All right. So, Stephen, I don't think number 2 there changes anything that you're currently doing.
Okay.
Number 3 is a typo, should end after general circulation. And that's, advertising in accordance with the Code of Virginia. And maybe we could just stop it after and applications must be advertised in accordance with the Code of Virginia and the zoning ordinance, full stop. We could actually end there.
Yes.
Yeah.
Put a period there. Because one of these days.
Yeah.
One can dream.
Yeah.
Well, that's the only thing keeping the newspapers afloat, these legal ads. Number 4, got to follow the Code of Virginia and the zoning ordinance for abutting neighbors. Number 5, we say they're responsible for additional outreach per the notice to applicants regarding neighbor outreach policy document, which is on your website. And I'm not quite sure what happens if somebody doesn't comply with that, but we don't address that here in the BZA bylaws. That's a question for somebody else to decide. Oh.
And then usually
That would make sense.
Depends on the, right. But
how
how egregious, if it's a back porch and it's a across the street neighbor, then it will likely move forward, but it can.
Right. Yeah, well, number 6 is an alert, because this came up with the Myers cases, which is I went back and forth with their attorney numerous times that, well, you said 5 days and then you said this other day, and you said the staff was going to give it to them on this day, and I'm like, let's just put it in the bylaws. Then everybody knows that this is what we expect, but failure to adhere to these timelines may result in the BZA deferring the hearing. That's the only penalty. If you don't make these timelines, you may get a deferral.
And I know, you know, among the board, we have had strong feelings on supplemental material, and that is just hopefully codifying what our practice is.
Right.
I don't think the intent here was not to make any changes. So if changes are being made, then we got it wrong.
Yes.
Right.
Well, you can say it's right here in black and white. Number 7, Code of Virginia governs ex parte communications. That's there solely for people who don't practice before the Board of Zoning Appeals on a regular basis, because they won't know that. They'll probably have to Google what ex parte means, and then they'll find the code section, hopefully in the Code of Virginia, and understand that they can't communicate to you individually or as a group without also communicating with the staff on any substantive matters. And then the last one in Article 6 is the summons of a witness. I did this. I actually got it done. I know. I'm going to put that on my odd things that very few lawyers have done list. And it's a thing that can happen. Were there any other questions about Article 6 before we move on? Okay. Article 7, there was a question about, well, it's just a notation of an error in 6A about the amount of testimony for representatives of groups. They only get 3 minutes, not 5, as it was in my draft. Then on the next page, there's another gaffe. 12B should be affirm or reverse, not affirm and reverse. Don't know how you do that. And then on top of page 10, there's a comment about paragraph 15. Question of how to capture it for the minutes. And this kind of turns into a discussion about findings, factual findings that you might make. If you want to write out something at a later meeting, not that you necessarily will do that very often, but if I had a case recently where the maker of the motion spoke for 4 pages of transcript and said at the end of it, "That's my motion." Well, how's the chair going to repeat that motion? So it's often a good idea to have findings of fact, and a well-prepared litigant will have draft findings of fact. So your staff report might have, we ask you to make these findings. And the applicant or the applicant's attorney might have a request that you make particular factual findings. In which case, if you agree with those, you just pick one side. If you don't like either one of them, what do you do? Do you do something off the cuff? And particularly since we just had a case this year where a variance was overturned. Was it a variance? Yeah, it was a variance that was overturned in the Court of Appeals because the circuit court didn't like it, and the circuit court's presumption of correctness trumped the Board of Zoning Appeals presumption of correctness. So it was a mess. I think it's good for us to think about making specific findings of fact when we can do that. And so that's an opportunity just to say here out loud, yeah, we don't have to vote tonight. We can put it on a later agenda, so I have an opportunity to draft some findings of fact.
Which is the next item to discuss on our agenda.
Right.
Because we haven't generally been doing findings of facts, although we've only had a handful of appeals since I've been a member.
Okay. And then there was a comment, voting. If a member is present for the vote, but wasn't present for the hearing, can they still vote? And I said, what are the options? Let's say you have the hearing in April and you have the vote in May because somebody wanted to draft some findings of fact. Somebody wasn't at the April meeting, they come to the May meeting, they reviewed the audio. Okay, well.
I couldn't hear the applicant. Yeah.
But
I would.
at the detriment of a 2-2 tie, or,
Still wouldn't.
you know,
If I didn't hear the actual.
because it's all recorded, you could go back and watch it.
Yeah, well, I'm not sure that a bylaw could prohibit a member from voting in that situation because they're entitled to vote. They're not required to recuse themselves if in that situation. So, right,
Right. Doesn't say you have to vote.
right. Yeah, it's just cleaning that up. Okay. Then I'm going to have to clean up the Article 8 on remote participation in virtual meetings because we just struck all of 6A through D, and then I didn't remove the references to them in paragraph 12. Oops. And then we'll also, you currently have a policy on governing electronic participation in meetings that we'll need to repeal when you adopt, if you adopt these bylaws. Good note on page 11, paragraph 9 there, that, you know, the proposed legislation may change this, the maximum number of permitted. And currently you can set it at less than the maximum allowed of remote participation meetings per year, but you can't go over what the Freedom of Information Act says. That may change. I mean, during the pandemic, the law on remote meetings changed 4 times in 3 years.
Say that each member's remote participation due to personal reasons be in accordance with the Virginia Freedom of Information Act.
Yeah, well, that's really pretty much what I said. Yeah, yeah, I just said it's limited to the maximum number permitted because otherwise you're not. No, that's just making clear that we're not setting a lower level. We're just saying whatever the FOIA provides is what the maximum number is. Okay.
Well, I think the distinction was that FOIA would let us make a lower number if
Yeah,
we chose.
I think we would have to say the maximum, otherwise it's ambiguous on how many days, how many,
In other words,
how many someone
the
could
VA
do.
say you only.
Meetings, since
So on that question, I don't want
Yeah.
to derail that.
Yeah.
The denominator,
Mhm.
is it meetings scheduled or meetings had?
Well, it's meetings had, but you get 2 free meetings. So you could miss the first 2 regardless of how many you had.
Okay.
For us who has 11 a year, the 2 doesn't matter then.
Right.
So.
Yeah.
Oh, I see.
does it include meetings like this?
Two.
Well,
Yeah,
A good
I think so.
question.
Meeting.
Yeah, that's
Yeah,
meeting.
why not? Right.
because
We've had a couple doubles this year.
couple, two.
Right.
2 last month, 2 this month.
Right.
And
No,
that's why-
it's meetings.
We had 2 January, 2 February, and 2 March.
It's meetings, not months. So,
But then it's always a fraction of how many we've had so far in the year
Right.
versus how many we potentially could have.
correct.
Okay.
Because you don't know. All right. And then there's a couple of typos on page 12 there. I had a hyphenated bylaws. I don't know, that was an artifact of something else that I did. All right. So I've got my notes here and you've got your notes. You're making some proposed changes. What I would suggest is that staff and I work on coming up together with a revised draft to tip to you. If we can't, if there are areas where we're still not in full agreement, then we can just provide both sets of language to you. That makes sense? Okay. Steven, you got anything else to add? Okay.
How much snow do you have?
Oh, it's beautiful there now.
68 degrees today,
But no snow?
so no snow.
Okay. Awesome.
So the second item, I just wanted a quick discussion on appeals findings because we've had a uptick in appeals and we have not really focused on any findings or the reason for them. So since Mr. Krim was here, I asked him to talk about a little bit about what findings are and why we should do them.
So the findings of fact are really critical in terms of the appeals and less so in other matters. But with the appeals, you're going to want to create a factual record to go up to the circuit court if it's appealed. or for other reference by staff and other people in regards to a particular situation as to what the facts of the matter were. If you have heard from the zoning inspector that they came and saw a particular zoning violation on the property, then you say, we accept that. We find that there was a zoning violation on the property as testified to by the zoning inspector. There's actually a case in the Court of Appeals right now. Well, it was in the Court of Appeals, and now it's up to the Virginia Supreme Court dealing with whether you have to consider Fourth Amendment search and seizure issues. Oh my goodness. So that's going to be even more important, I think, if that case comes down the way it looks like it's going to come down, where the Board of Zoning Appeals is going to have to make a determination about the exclusionary rule on evidence being offered if somebody objects to evidence. So we will, if that happens, we will come back and try to give you a crash course in Fourth Amendment search and seizure. But the idea behind findings of fact is to create the kind of record that the circuit court will be able to look at and say, okay, I know what the Board of Zoning Appeals found. These are the facts that they found. They didn't just say, we rule for the county, we rule for the appellant. The circuit court can say, well, this is exactly what they found. And that's a starting point for then the circuit court to accept additional evidence if it's so inclined.
Why wouldn't the transcript of the meeting be sufficient?
Yeah.
Well, the transcript doesn't say who you believed. If there's a conflict in the evidence, it doesn't say, or if there's somebody that you just don't believe, whether there's a conflict or not, the transcript won't give that information.
Except that usually we give our opinions.
But Judy, do
As
you
part of
remember the case where they wanted to build the house closer and it was appealed? And in our discussion, it was very clear what we intended when we denied it. And the court would not look at the content of what was said. They overturned, I think they took action on it. It was very clear from the discussion what we meant, but the court did not pay any attention to what was discussed.
Right.
I'm totally uncomfortable writing down and making findings of fact. We're not a court.
Mm-hmm.
And it is ultimately, it's subjective. It's our opinion.
Mm-hmm.
And I'm not comfortable doing that at all.
Mm.
So I don't think that that's my role. I think that I decide whether or not the appeals. I don't feel like I need to justify all of that.
We make findings of fact every time we, the resolutions.
I think writing it down.
No,
and writing
the resolutions.
Go into.
No, I was trying to explain the.
Yeah. Explain.
That's all right. I'm sorry.
You're talking to me like I'm a child. I've said my piece.
So the idea here, I guess, is again, as I said while we were having the bylaw discussion, if you have a staff report that says we think the facts are these, it's easy to say we accept the staff report's statement of facts as our findings. That's all you would have to say. And if the applicant has a different alternate set of facts, then they've provided that to you, you could say we accept the applicant's set of facts. That's how I would envision that working. Yes, ma'am.
So this is something that we do at the conclusion, after we have had the appeal hearing.
Right.
And made a decision, which is part of the record. But in addition to that, we're going to write up, someone is going to write up something. Like justifying our opinions, or what if it's a split vote? Do we then need each side to write up theirs?
No, what it would be is the person making the motion says, I find, I move that the board find that the facts are as stated in the staff report or as stated in the applicant's application, the appellant's application. And for that reason, I move to affirm, reverse. Right, and I'll,
Then just
right.
staff and from the staff report,
You-
that decision will be closed.
Right.
And-
So it's not a vote.
But do you
I-
remember when Peter was with us? We haven't had an appeal for a lot. He always wrote findings for appeals, and he'd go off to the corner and sort of write them.
On-
Mhm. Yeah.
So you have to do it, read it and.
Right.
If you're not, that would certainly make it easier. And a lot of times staff reports will have a draft motion. If you wish to affirm, this is your draft motion. If you wish to reverse, this is a draft motion. I've seen that.
Not on appeals.
Right.
On appeals, there haven't been findings.
We do that, right? So we'll give alternative motions.
Mhm.
And we can just, in our alternatives, just say I have what Martin just said, the sentence. We can add that to the motion so you guys could read it off. And it would be either or.
Right.
Like you agree with staff or you agree with
So-
the appellant or whatever, you're going to pick that to read. But it'll say the sentence that
So
Martin
it's a more
suggested.
detailed motion and we don't have to supplement it with anything?
If,
Or are
well,
you saying we still should?
no, I'm not saying you should. I'm just saying that there's an
Yeah.
option. The maker of the motion could say, I would like to have some time because I think that the applicant had some good points, but the staff had some good points. I didn't agree with everything that the applicant said. And so therefore I would like an opportunity to draft that and either like Peter, go off in the corner and do it or set it for another hearing before the vote. Correct.
To be,
And if you remember back when we were hearing the Myers case, if the vote had gone in the direction I was voting, I would have wanted additional time to come up with the findings. Right? Because I think that case is getting appealed no matter what. I think it is, or it has already. And it's helpful to build the record for the appeal so that the circuit court has something more to go off of.
I
And-
feel comfortable. The attorneys prepare that.
Yeah.
So that we have, they have explained much better than I certainly could draft. I mean, I could write you a paragraph that says, this is why I feel the way I feel, but that's also part of the transcript because we make our pitches also.
Right.
But if there's a way that the motions themselves can be a little bit more fleshed out
Hmm.
with the rationale or whatever, I think that would be a good step, even if it doesn't preclude having to also do what you're
Right.
talking about.
And if you look at like one of our normal use permits or variances, we're required to make findings of the bullet points of hardship, compatibility with the neighborhood. And I think the staff does a great job on doing that for the more common use permits and variances, but the appeals ends up being so much more specific. And sometimes, as I think we all know now, the arguments that show up in person are totally different than what shows up on their papers. And so I think that there's only so much staff is going to be able to do on some of that.
Well, and because the motions that we typically make
Right.
either affirm or kick to the curb. I mean,
Right.
they don't have any substance to them.
For the appeals.
The report does for the appeal. And it's just because we're
Right.
being asked, did our vote get it right or wrong?
Correct.
And we vote right or wrong, and there's no real elaboration. So I think it would be good to have a little bit of a whereas or two
Hmm.
before.
Especially if we're affirming the, you're here and you have an opportunity to put those findings in, right?
Just practically, I'm not sure we can put in whereases.
Okay.
Because we're going to
That's
have to put the whereases in for the other side.
Well,
That's not going to really make sense, but we can certainly put the introductory
the
language.
justification.
right.
Yeah.
No, I move, the board find facts are as stated in the staff report. And, the motion would be like after that, it would be what you're used to.
Right.
And the alternative motion would say, I move that the board find facts are as stated by the appellant. and then go on.
Yeah, it could be as simple as
I mean, that's what we can certainly prepare. So y'all have something to read off of.
right.
But I don't think that, we can't anticipate what, sometimes we don't even know what the appellant is
That was my
trying to
point,
say.
right?
Yeah.
Right.
So like, we can't anticipate that.
And hopefully the appellant would come with their own proposed statement of facts. Yeah, no, I know.
I think we
Which
actually
was not
requested-
helpful. The Myers
Yeah.
statement of facts were not statement of facts.
But they were
So-
like 200 pages. the
Those
statements.
weren't those weren't anywhere near what it should have been, right?
Right, okay. Are we all clear on that? Okay, good, thank you. Looks good. All right.
Appeals hearing scheduling policy development. So Blake, I don't know if Blake, you want to talk about this more, but Blake and I have had a lot of conversations just about how to schedule these appeals now that we've had like a 2-year break in appeals scheduling. And I'll let Blake talk, but I think our sense is that I think staff wants us to schedule appeals formally for the, during one of our hearings.
Is it working?
Just, like I did at the last hearing, like I or who's ever chair would say, I understand we have an appeal to schedule. And then we could throw it to Blake, and then Blake, we have appeal number 654 proposing to schedule on June 6th for your normal hearing. And then the chair would ask for unanimous consent to do it, something like that. And preferably we would get, the chair would send an email out to everyone saying, hey, we have an appeal. The plan is to do this on, our normal hearing on June 7th or, whatever it is.
Yeah, I think with the recent hearing last week, you scheduled the appeal for June, and the next day the appellant in that case was like, "Thank you for having that scheduled," and it was.
And
Thank you.
I think the idea is, transparency, and that gives the public, everyone knows it's going to happen. The parties know, and it just is, as opposed to just waiting for it to be on the agenda 2 weeks before. I think it gives everyone more certainty.
So summarize, how would this change what we do now?
So I don't know. So appeals are new to me. So I don't know how we do it now, right? So this is all new to me. So I don't, I can't speak to that.
Being more notice on the website?
I don't think we've addressed. I don't think that we've even talked about that. I think this is just for getting things like actually scheduled for appeals.
Yeah, we certainly don't want to like proactively add an item to an agenda that you haven't consented to hearing. I think that would be in violation of your motion from last September. Or could be.
False. So if I could just restate, as I understand what you're proposing to do, the staff would bring an appeal matter to the board, just say this is an appeal by such and such from zoning violation number such and such. And we're proposing to schedule this for June. And is that acceptable to the board? And so in terms of policy, that's like a 1 paragraph, I think.
Right, and so like what we did last week is then I just sought unanimous consent from the BZA to schedule this for this date certain.
And the reason to have a policy rather than just have a practice would be to let people know that that's what they can expect.
Right.
Okay.
But then that doesn't answer the issue of whether it's on the regular agenda or a separate agenda, because if in June you don't know what the caseload is.
So then I think that the appeal would be scheduled, and then the use permits and variances would then move to an overflow day or another date in the future, depending on what that schedule looks like. If we have 25 use permits and variances, clearly we're not going to hear them all of them on the same day as an appeal. And so those would be the ones that would have the flexibility to move because the appeal is more certain.
Okay.
Okay.
Does that sound? And so I think everyone's on the same page. And so this is, I know we've done this in the past where I've scheduled something and then staff says, oh, no, you weren't supposed to do that. So we're trying to get everyone in agreement on the policy. And then I think that was basically my agenda. And then Blake and his team had some stuff to cover as well.
Thank you. Yeah, the next item is the status of the very often seen variance request in Fairlington. This is a very short item. The status is that comprehensive planning is working on a zoning study for action in the fall. So sometime in the fall, we hope to have a potential zoning ordinance amendment that will rectify the need for all of the variances that you're seeing in
Is that the
Fairlington
start of it, or are we hoping it gets before the board in the fall?
before the board in the fall. It's underway as we speak.
Fantastic.
Yeah.
Does the planning commission?
It's comprehensive planning, and the planning division is working on it. Mhm.
I think I just noted I know annual report is later, but it was dramatic how many Fairlington cases as it, outright as a percentage of the total cases, as by, runaway train, the biggest civic association. And if that isn't a demonstration of a system that's broken and needs fixing, sooner the better. I mean, fall, okay, if we have to wait that long. But this has to be fixed. And particularly because right now, the makeup of the board is such that unless everybody shows up, these people who are going to be penalized for living in Fairlington, where no other homeowners in the whole county are subjected to the same kind of treatment in terms of making interior modifications.
So
It's just absurd and it needs to be fixed.
there's a quirk where this group of townhouses have to seek a variance in order to do interior renovations to their house, or a window well, for example, as well. And so historically, we have a split vote of 3-2 under the premise that that's not a proper use of a variance.
But we're
But
sympathetic.
under sympathy, right?
So it's a kind of a gentleman's agreement that we vote through. We're not unanimous.
And I think that my hope is that being 3-2 helps get more attention to it and gets it to the county board. But maybe I'm over optimistic.
Are you able to say whether the change will result in making all of these by right? You don't know the direction of the.
I haven't even talked to them about it. I think they've been talking to Blake, but they're just starting the work now.
Yeah, I think in addition to things like window wells and kitchen renovations, they're also looking into the possibility of some exterior modifications, things like decks. So it could be a bit expanded from the kinds of requests you're seeing now, but I think generally in the scope of the kind of the kitchen renovations, the attic renovations, and the basement remodels with window wells that are coming to you at the moment.
Is your sense that they would be by right, or they're just going to be changed to a different category that comes to us as some
I
kind of other
believe
permit?
the intent is to go towards by right. From my discussions, I can't, of course, say without looking at each individual application what might be by right or not.
It certainly won't make it worse.
If they come to us as a use permit, it changes everything.
It does.
Yeah.
Yes.
But
It's a different.
they still have
conversation.
to pay a fee and go through the
Right.
process.
It's time and right.
Time and money.
Right.
But other people don't have to do
When-
use a permit either.
Other
Depends-
apartment
depends.
buildings, yes.
Right.
Most of the people you see are single family, but it's not just Fairlington. It's any
We do get other window well
complex
cases.
with multiple apartment buildings. So that's just a big one.
These are just town stuff.
Yeah.
It's mostly good news.
Back to you, Blake.
Okay, just jotting down some notes.
I think it's me.
Oh, is printing a BZA staff reports not you?
Yes.
Okay, sorry.
So we are going to change our process to become more environmentally friendly, to suspend printing paper staff reports and applications. I did an informal survey of the boards and commissions that our department engages with, and this is the last that I know of that still actually prints paper every month and delivers it to people. It's costly. It's a lot of staff hours spent manipulating paper that we would prefer not to do. I did also in my research find that for some boards and commissions, the, I guess, process improvement that we would start is having a more detailed discussion with visuals in our presentation at the hearing, so that up on the screen, everyone is seeing the drawings and the information that we're referring to, and that's the public watching online as well as the people in the room. So it's clear about, where this addition is, what setback we're talking about. And so we would kind of supplement our discussion of each case with more information here at the time of discussion to help make sure everybody knows what's going on and where it is and what we're talking about, instead of assuming everyone is looking at the same thing in their various packets of paper. But
I'll
that's,
try it. But it'll probably
Let's
send-
try it.
It'll probably send me packet.
let's try it.
Me. I like having my notes and writing it out and reading it.
Yep.
Sometimes when you only have a cell phone available, it is not good reading those.
Or even just a standard laptop screen.
Yeah.
If I had big stuff like you guys, it'd be different.
Martin, do you have a sense of what other BZAs do?
I think the best electronic.
Not terrible. Do figure it out. I've never gotten a paper
Okay.
packet.
Let's
Get used to it. And it is, everything else we do is on.
Is that starting immediately?
Yes.
How about supplemental materials?
Aren't those already coming via email?
Well, we get them at our
Get
desk.
them at the desk, because a lot of times we don't have time to read them during the day.
Shouldn't be
So
too
I
much to
think
start
the
with.
other, this might be, somebody else suggested this, it might have been Stephen, that we we used to, and I don't know if we stopped doing this, have a kind of a table copy that we bring, like one copy of everything to the
They do
meeting.
QRs.
Oh, okay.
Yeah, no, I mean, I'm just for us, because I know, we all work during the day, or I don't think we, so a lot of us work during the day and don't, if we
So
get here at 6.
doesn't your policy say if someone submits something less than 5 days, they need to bring
It
you
does
paper
for,
copies?
it does for applicants, but if the neighbor, sends in something, I don't think we have any authority to tell them you must
You
bring
do.
it.
We used to tell people that all the time.
Because that was, I think that was the discussion that we had with staff
We,
not too long ago.
when we were a paper application model, we told people who called at the last minute, bring copies. If you're coming to the hearing with something that we don't already have,
What if they,
you need to
aren't
bring
coming to-
copies for everybody.
what if they're not coming to the hearing and they submit the comment submission form
What
at
kind of-
noon on Wednesday?
I don't know what our cutoff is for when, we can't receive and process things that are coming in that late.
Normal,
And
Normally,
have them-
normally we get,
and
normally we
have
do.
them here.
Normally we get them.
we have them at our place when,
Yeah.
After noon?
Yes,
Yeah.
because,
5 o'clock, you can get an email that says supplement.
Right, that's what I'm saying. It's coming via email. All of those things are coming via email. They're not being printed.
but we get all the supplemental.
We get them
right
all at
now
our desk.
when we
Anything
were-
that comes in last minute, we get in our desk.
Yeah, we have been printing all the supplemental materials that come into us after the original packet is printed. And we have been printing those for the BZA ahead of the hearings.
Yeah, I thought we were,
They are
I thought we
linked
were
as on the website
posting
as
them.
well, yeah.
I don't see how that would be treated any differently than anything else.
Because I think that there are a number of us who would not be reading the supplemental
Line.
online if it comes in like day of.
Maybe they should.
I think that's, yeah, I think that's legit. Like, you shouldn't be responsible for reading it if it's coming that late and expected to
So-
talk about it in a few hours.
So a lot of it is neighbor feedback that comes in late. So what that might result in is more
More
deferrals because, they just didn't get it in. And so, because right now Patty will try to, remind people to send it in, but, she only starts when she sees the packets too. So
Can you get Patty to put them for you?
She doesn't come in.
I could just look.
They
it up.
couldn't hear you because your mic is off.
anyway, that's been helpful to have them, because that's who's going to get penalized, is the applicant, if we don't, get those in at the.
Yeah, I mean, I don't necessarily have any objections to getting, I mean, I used to get the materials in electronically, and it's a little, I don't want to say harder, it's a little different and a little takes getting used to. But I guess the concern I have is just the supplemental.
We can talk about it, but to me, there's no distinction. And I think it is unfortunate if a few people have to,
It's
More than a few.
right?
Yeah.
I mean, that's your decision. If
Yeah,
you think that neighbor comment is important enough to defer action on an item, that's your decision.
It will happen more.
So if
You can't get paper.
so if someone gives feedback on, I don't know, Tuesday, what's your plan? What would you do? Just post it online?
That's what we do
Or
now.
Okay. So
A lot faster.
what's the cutoff? What's the cutoff? And then do you tell if anything comes in after the cutoff, do you tell them to bring it to the meeting, or
Yes.
just no contacts?
Yeah, we typically,
So like,
if we get,
what's the cutoff, and then what's the message?
for like BZA comment forms, emails, additional supplemental submissions, and that we receive 5 p.m. the day prior to the hearing is the latest that we will incorporate it into the packet.
I'm sorry, 5
p.m. the day prior to the
day
hearing.
prior. Okay.
Yes, so if we'll come in Wednesday morning and we'll have cut off the supplemental materials packet the previous evening. So then we come in on the day of the hearing, we'll assemble the final packet and send it to you guys midday.
Okay.
And then anything after midday.
Which happens with some frequency. We'll tell them if they want it to be considered to bring 6 copies to the BZA hearing in person.
Okay.
When are the packages available online?
2 days before you get them now. They're available on Wednesday. Yes.
Yeah,
I've
usually Wednesday evening.
If there's an update, do you send out notices that you've updated it as of 5 p.m. the day before? So that people know to look for it?
Generally, they do.
Okay.
Yeah.
They send me here to give the bad news. And I just realized, I know it's off agenda. I just want to introduce Debbie Albert, who's been sitting patiently listening to this, who is a new-ish member of the zoning division. I don't know that some of you have met her. Debbie's worked for Arlington County for many years, initially in the planning division, and did a lot of zoning ordinance text amendments for many years, and then took over Herman Arlington, and then now is back as a deputy zoning administrator in zoning. So she oversees Stephen and the entire team. So just wanted to.
She's a natural for the job.
Yes.
She really
Yes.
is.
That's it for me.
Oh, that was all good news.
Try to end on a positive. I know.
Is there a print budget that we can see that?
A good question. Talk to Paul.
All right, the next item we have on the agenda is something we tell you guys about annually, pretty much. It's the VCU training programs that are available to educate members of the public, including BZA members, as well as in certain cases, zoning division staff about the BZA process. So we have 2 opportunities this year. One is in person. That one's first, starting in June, and then there's a virtual offering later in the year. The in-person offering is down in Richmond, and then the virtual offering you can obviously do at home. Cost has gone up this year. I believe it was in about $550 last year. It is now closer to $660, I believe. It's on this 600 at the bottom of the slide, yes. So it's increasing cost a little bit. I think we are planning on potentially sending one of us this year, Meg, me or Brett, probably not Meg under the circumstances, but Brett or I as a possibility. But of course, it's also open to the BZA members.
Did I just hallucinate that it used to say June?
There's two. There's a
Okay.
virtual, one slide is for the virtual session and one is for the in-person session.
So it's June 20th and 21st. And then the closing is
I believe in August for that one.
August 30. Okay.
I think I sent around the in-person one, but I don't think I've yet sent around the virtual one to everyone. I think that was a relatively new announcement on their part. Yeah.
Is there a cutoff for applications?
There was no registration deadline mentioned on the website.
As long as there's slots available. Sometimes it fills up.
Yeah, I believe the virtual session had less spots than the in-person session.
And if BZA members would like to go, my understanding is funding is generally not an issue. The circuit court will cover that. It's like, I think it's one hotel night. It's so the intro session is 2 days in person, and then the exit session is 1 day in person. And you could either drive up in the morning and rough it back and forth, or stay the night before. So I just took the in person December-ish, November, the last fall I took it. If anyone's interested, let me know and I can work out that funding.
Okay. Any questions on that or good to move on? The next one is you were just given a draft copy of the annual report yesterday, so you might not have had much chance to review it in detail. Stephen was the author this year, so if you have questions, we are available, particularly Stephen has the most information on it, to answer them.
When are we hoping to get that out?
It depends on how many comments we get.
Okay. I have not, so I myself have not had a chance. I skimmed it, but I haven't read it.
I will say this is still, I would call this an early draft.
Okay.
There are heat maps that we've done years past that have been very popular that are not incorporated yet, just because I haven't been able to work with the staff who generate those for us. So there will still be some additions, but this is, I would say, the content is pretty much what we normally have, and is pretty much there.
Stephen?
Yes.
Did anything surprise you?
Well, I think Judy already pointed out kind of the largest change, and I don't think it's anything unexpected to all of you. The largest number of cases by civic association was by far Fairlington this year. It was about probably 150% of the largest number of cases that we had for any civic association last year. The other interesting thing of note this year, I hadn't noticed it in the past, and I've done a number of these reports now. The percentage of use permit approvals was 100% last year.
Nice.
And I think that is the first time I've actually seen that percentage reached. So just
What? All use
100
permits?
We haven't denied
all
a
of the
single
use permits. None were denied last year.
That's,
We did negotiate with some though.
Yeah, I think
Yeah.
a few were deferred, but then approved.
Yeah, we
Yes.
did negotiate with some.
or are you feel like you're screening
Yeah, staff must be screening better.
things that, aren't, encouraging people to make corrections that they don't think will come through?
I would defer to Blake on, I wouldn't say that we're screening, and I don't want to give any indication that we are not bringing things to you.
Right.
It's always the applicant's application, but I do think staff spends a lot of time working with applicants on applications before they reach you, so that they are as good as they can be, as clear as they can be by the time they do reach you.
Interesting.
Yeah, I would agree with that assessment. I think based on feedback we get from you at work sessions like this and meetings throughout the year, we have become very deliberate in telling people what you guys expect to see, especially in regards to neighborhood outreach. We might have used to previously said things like, oh, it's not our legal requirement, but the BZA likes to see it. Now we say things like, you will probably be deferred if you don't have neighbors in writing. Yes.
It's not a legal requirement, it's a BZA requirement.
Yes. Now it's in the bylaws. So
So, The other question for timing is a cover letter from
Yes.
BZA. Normally, we do some kind of a cover letter. Usually, we summarize anything that jumps out at us that requires, should be brought to the attention of the board.
Right, I wrote that, last go around, I highlighted the R27 and the Fairlington.
I don't know if anybody off the top of their head has any thoughts about anything else that needs to be highlighted, but it ought to be, it ought to be included if there is something that jumps out. And even if staff thinks there's something that, we should be highlighting. Because the other thing that seems to have dropped off is the R27s.
Yeah, we haven't had those in a while now.
And that's just
Good.
because nobody's doing those, or maybe maybe they're all done.
Visuals.
They're working on it, right?
They're going to be added. Stephen, you're going to add a little color and visuals?
Yes, ma'am.
But
Those
it's
heat
very,
maps.
I thought it was really excellent.
Thank you.
Yes, and I would like to publicly thank Stephen for taking that off my plate. We've been very busy this year and appreciated having that task handed off.
Sounds like it's officially going to be every year, Stephen will do it.
Let's hope we're not as busy every year as we have been so far this year.
By the way, not an agenda topic, but the EHO discussion at the board yesterday was very interesting. The board members took up extended housing option, asked for a status report. I thought that was interesting. What surprised me was, given all the applications that we had last year, there's only 2 building permits that have actually been issued. And my question was, once a building permit is issued, how long? They have forever to build it?
Yeah.
Do they
Year.
expire like site plans?
I think it's a year.
It does expire. I forget if it's 12 months or 18,
But
but
But you can renew
they
it?
can renew it.
My suspicion was that people were going to apply because there's a cap, an annual cap on the applications, but not necessarily pull a permit right away.
Mhm.
I don't know if there's a time limit. Is there a time limit from the time they're approved?
For the zoning approval, no.
So they get the permit, they could wait years.
I mean,
They don't, but they
Yeah.
could.
conceivably, yeah.
The other thing that was interesting was the discussion that anything 4 units or greater had to be built according to
Commercial building code.
standard, commercial code, not residential,
4 or greater?
Yes,
which
But
I
that
think
surprises a few people.
it did.
That
They were not
that may
prepared.
account for the
Yes,
Not so many building permits.
that's true.
And they go,
Yeah.
oh, what?
That's exactly why.
Yeah,
It's a totally different set
Well,
of
it may be-
requirements and
inadvertent way to slow that train.
well, the
they
big
were
ones-
excited. They came out and then they learned quickly exactly what was going to be required of them.
But
So
the 2 that we heard were 6-unit, 2 6-unit
I think
buildings.
one was a conversion of an existing dwelling from like single family to 2 units. And I think the other was a multi-unit
The
building.
Alcova Heights was 2 6-units.
Yeah.
Oh, you mean that
That's
you've
on the
heard?
site
I'm sorry. I thought you were talking about
That
that
we
have
heard.
building
No,
permits.
that
Got
we
it.
heard. And
Yes.
so those 2 would have to be built to commercial
Yeah, because
standards.
Yeah.
Monroe Street, 14th was a back it down. I don't remember how many.
And the third thing that was interesting was that a conversion of a single family home into multi-units may not work because of the footprint
Of the
individual
single family house is so large.
is so large that you can't have,
It exceeds
Oh,
the
unit
standards we
that
just
big.
created. Yeah.
that they have footprint limits. And so to take, the idea that you take a huge house and make it into 4 units
Right.
doesn't work. That's something that the board can fix.
Yes.
That, the building permit stuff, the board can't fix that,
Right.
but they could fix that part of it. That was a very interesting presentation. A lot of interesting facts.
We keep learning.
Yeah. Okay.
I think it's time to, your last item, you have one more item,
Pitching hour.
elections.
Election.
Here, before we start, this is going to. Way more than I anticipated, and I don't like the direction.
Yeah, it's too bad.
Your elections are coming.
I will nominate Rick as chair for the next year. He served 1 year. Sometimes it's been typical, not always, that the chair serves for 2 years. So that's my nomination. I guess I need a second.
No, you don't need.
That we
Or not.
I know.
Our practices.
Oh, your process. Sorry.
Okay.
I'll shut up.
And I guess I'll call the roll.
How does that work? I don't even know.
Yeah, Miss Freshman, Miss Clark,
Aye.
Miss Malice votes aye.
I guess it's,
Kaplan, you're elected.
I mean, did I have to accept? You
We didn't ask you, did
didn't
we?
ask me, no.
All right, now we have a vice chair election.
Yeah, do it. So, okay. Any nominations for vice chair? Miss Malice, are you interested?
I'm willing to accept.
Then I will nominate Miss Malice.
Oh, I didn't ask you.
No, you didn't. I got forced into it.
You need a second.
We have a second.
Oh, that's,
Exactly why I'm not staying.
All in favor, say aye.
aye. So, question,
Yes.
should we vote on the secretary today, even though we don't know?
Does secretary have to be voted on every year?
Well, we put it in our bylaws, in our potential bylaws.
Yes, that's. Okay, I was just had the statute up on my phone. The secretary, let me just do a word search for that finding page. Secretary.
And also Patty. Patty stays unless she's changed.
Yeah, that's not an official position.
Okay.
So it doesn't say that you have to vote on that, and if you don't take action, then the person currently in the position continues until you make an appointment.
So we'll just.
So why don't we just let it ride
Let it ride.
That's
and
all
not
right.
not give like a choice?
Staff, don't, yeah.
No change.
Is that- Are you on for another year?
Do you agree? I mean, is that all right?
Sure. I feel like we still have work to do on this.
Yes.
which
Yeah, well, we haven't
may,
approved that.
like solidify the
So,
division of labor, so to speak. Was that still,
yeah.
I will
think-
admit to not paying 100% attention during that
I-
part of the
Because you
meeting.
were so worried about having to make this announcement to us.
Yes.
I mean, my
So it seemed, I mean,
My sense-
continuing what we've been doing doesn't bother.
yeah, I mean,
me.
my sense is, I mean, if we separate the, the secretary role from the liaison role, I'm not sure the secretary role has much responsibilities, right?
Yeah.
I mean, so I'm not inclined to,
Yeah,
want a huge change from our current practice.
got it.
I mean, but that's me, one of four.
Yeah.
And, but I sense that not anyone here wants any big change. So I think
That's fine.
yeah. Again, I don't think we're trying to make any changes. We're just trying to document. But
Any-
clearly some of the wording
I mean,
looked like we were trying to make
The
changes,
job is not big.
which was not our intent.
Job is not big if it's not what Blake does. All right. What is this the agenda having been completed moment?
Yes.
Oh, but just a timing wise,
Hmm.
you'll make the revisions or you're gonna
I'll
wait
work with
for,
staff and we'll come up with a revised version, and it may have version A, version B, but it will
and,
clearly mark those.
and then we could adopt at a regular hearing.
Yes, ma'am.
My sense is that there aren't a whole lot of fully controversial items that we talked about. I think it was just a lot of wordsmithing to
Yeah.
meet everyone's concerns. Yeah.
I
No,
want to thank Mr. Krim
Oh,
for taking us so far over the line, because we, like I say, what did I say, 17, in June of 17, we were starting to meet on this. But very much appreciated.
Okay.
Need a motion to adjourn?
The agenda having been completed, this meeting